So these are some frequently asked questions about the Brown Act open meeting law. What is the Ralph M. Brown Act? Well, the Brown Act was adopted in 1953, and it applies to open meetings at the county and city levels of local government here in the state of California. Where's the Brown Act found in the law? It's found at Government Code sections 54950 and those following. What is the purpose of the Brown Act? Its purpose is to guarantee the public's right to attend and participate in meetings of local legislative bodies. What did the proponents of the Brown Act originally say? They argued that city councils, county boards of supervisors, and other local government bodies were avoiding public scrutiny by holding secret workshops and study sessions. How did the Brown Act differ from other open meeting laws? The Brown Act solely applies to California city and county government agencies, boards, and councils. It's comparable to the Bagley-Keene Act that requires open meetings for state government agencies in the state. What legislative findings and declarations are contained in the Brown Act? The Brown Act contains several different findings and declarations, including in enacting this chapter, the legislature finds and declares that the public commissions, boards, and councils and the other public agencies in this state exist to aid in the conduct of the people's business. It is the intent of the law that their actions be taken openly and that their deliberations be conducted openly. What is the basic requirement of the Brown Act? A majority of a decision making body may not decide among themselves on issues within their jurisdictions, except when in open and publicized meetings held within their geographic boundaries. In addition, local agencies must publicize when and where meetings will occur, as well as what will be discussed so that the public can observe those meetings. What is the notice requirement? It's 72 hours, basically 3 days' notice is required. Is the Brown Act notice different than other open meeting law notices? Yes, it is different than the 10 days notice under the Bagley-Keene Meeting Act for state agencies and departments. Can votes be taken outside the public's viewing? No, there are no secret ballots allowed, whether final or preliminary. What is the right of the public to comment on agenda items? The public has a right to be heard on matters on the agenda before decisions are made. Can the public speak on any items? The public does have a general right to address decision makers on items of concern to them, even if they are not on the agenda, typically called a public comment period on agendas of local bodies. Does the Brown Act prohibit a series of individual meetings of a decision making body? Yes, the Act prohibits so called serial meetings. Does the Brown Act cover committees and advisory bodies? Yes, it does. What are the penalties for violating the Brown Act? They're almost identical to Bagley-Keene penalties for violation of the law. Are there any other requirements that must be met? Yes, for example, a member of the public must act within 90 days of the alleged Brown Act violation, and the agency must be given an opportunity to remedy its Brown Act violation before the filing of a civil lawsuit to enforce its provisions.